Thanks for watching. This video explains how an IIO investigation works. We'll discuss what types of incidents we investigate and the reasons behind those decisions as we take you through the life of a file. An IIO investigation begins after a report of serious harm or death involving any officer or detention guard in BC. Legislation mandates the IIO to investigate these incidents. Agencies must report all incidents meeting these specifications to the IIO. An affected person, their friends and family, or even a witness can also report an incident to the IIO. The IIO's mandate extends to all on or off-duty RCMP, municipal, transit, and tribal police officers in British Columbia, as well as special municipal constables and special provincial constables, essentially anyone who's an officer under the Police Act. Its mandate was expanded in September 2025 to also include all civilian detention guards in BC. Every case is different. For example, not all broken bones or police dog bites meet the threshold of serious harm. A serious bone break requiring surgery, permanent impaired mobility, or a dog bite that ends up needing substantial medical treatment may be considered serious harm. At the same time, a person may suffer serious harm or die, but there is no direct connection to action or inaction on the part of any officer or detention guard. A report is made to an on-call team director at the IIO who is available 24 hours a day. That team director will determine if the case meets the IIO mandate. If it's clear from the outset that the incident does not meet the IIO mandate, the report will be closed as a non-reportable file. An example of this could be that the matter does not involve any officers or detention guards at all, or doesn't meet the criteria of serious harm. If the mandate is met, an investigation continues and the file is assigned to a primary investigator, or PI. If it becomes clear during an initial investigation that there is no serious harm or there is no link to officer or detention guard action or inaction, the investigation can be assessed as non-jurisdictional and closed. All IIO investigations are conducted to a criminal standard, and the length of time they take depends on multiple factors, including the complexity. The IIO attempts to be as transparent as possible, and in many cases we will publish an initial media release around the same time we start an investigation. The IIO operates with 4 teams of frontline investigators, each with a team director overseeing it. Once a file is assigned, the primary investigator becomes responsible for conducting the investigation. They are overseen by their team director and assisted by another investigator known as the file coordinator. Collectively, this is known as the command triangle, or CT. The primary investigator will normally, but not always, attend the scene of an incident with other investigators and, if necessary, members of the IIO forensics team, who are specialists. The investigative team will begin investigating by collecting evidence and speaking to witnesses. Once circumstances become clear, the command triangle will meet and eventually designate any subject officers or detention guards and witness officers or witness detention guards. We just mentioned designating a witness officer or witness detention guard and a subject officer or subject detention guard. A witness officer or detention guard is involved or is present during an incident and is compelled to speak with IIO investigators. This means they'll generally be interviewed by the IIO and provide notes or other evidence and information to investigators. A subject officer or detention guard may face criminal liability because of their actions or inactions during an incident that resulted in serious harm or death. A subject officer or subject detention guard's rights are protected by the Canadian Charter of Rights and Freedoms, including the right to silence. The IIO does not force their cooperation in an investigation. The IIO has separate videos on its YouTube channel dedicated to what to expect as a subject and witness officer or detention guard. During an investigation, the IIO will gather all relevant information to complete a fair and thorough investigation. That includes gathering witness statements, video footage, hospital and other medical records, as well as any relevant forensic evidence. It also involves reviewing police records, radio transmissions, and 911 calls. Once completed, the IIO will consider all facts and evidence collected during an investigation to make a determination as to whether an officer or detention guard committed an offense. For example, in cases involving the use of force by a subject officer, the evidence will be analyzed to determine if the actions and any force used by a subject officer was reasonable, proportionate, and necessary under the circumstances. This slide explains the file review process. Once an investigation is over, the file's command triangle presents its findings to the Chief Civilian Director, or CCD. Legal counsel and the Chiefs of Investigation are also present for the file review. The investigators present the evidence, analysis, and theory of the case to the CCD, who then makes a decision on whether the investigation can be concluded and next steps for the file. The CCD can choose to conclude a file in one of three ways following a file review. If they find there are no reasonable grounds to believe an officer or detention guard may have committed an offense, the file can be concluded by issuing a public report. This document is published on the IIO website and linked on Facebook. A public report details the evidence, legal principles, and rationale for the decision. The CCD can also arrive at the same conclusion but decide a report is not in the public interest. This may be because it conflicts with privacy interests or involves a sensitive matter such as suicide. These files may in some cases be closed by publishing a shorter concluding media release. In all cases, names of officers or detention guards, witnesses, and affected persons are omitted from any concluding documents. If the CCD decides reasonable grounds exist to believe that an officer or detention guard may have committed an offense, the file may be referred to Crown Counsel with the BC Prosecution Service for consideration of charges. In cases of a referral to Crown, the IIO may issue a media release but will generally not comment once the file has been referred. At the start of an investigation, the IIO may issue a media release confirming its involvement. Media releases do not contain a lot of detail, and the IIO will use nondescriptive language like weapon or vehicle. This is done to avoid prejudicing an investigation. In other cases, the IIO may limit details with respect to age or gender of the affected person in order to protect the AP and their family's privacy interests. The IIO may also publish a concluding media release when an investigation is closed. This can be done instead of a public report. If you have any questions, please call the IIO at 1-855-552-4622 or email us at info@iiobc.ca and we'll be happy to assist you. Thanks for watching.